This is a case that was reviewed by the court, and a petition for emergency removal was approved following a prelim conducted by the referee. So we have both parents back today. It was continued because I think Ms. Underhill lost connection or something. We had a brief sidebar before we started just to talk about what effectively needed to be done today. And I'll leave our attorneys to cover that after appearances.
Lee Tice, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. Trout.
Hannah Trout with the department.
Michael Brooks, I represent the father, Zane Ridenour, who is not called to be here today.
Well, he's actually here with us from the jail. Mr. Ridenour, can you hear us okay?
Yes, ma'am.
Thank you.
Michael McFarland, representing mother, Ms. Underhill. Please introduce yourself.
I'm Brittany Underhill, the mother.
Thank you. We'll try not to use the children's names as they're being broadcast. Thank you.
You have a motion.
Your Honor, we had a preliminary examination that was proceeding in front of the referee on Friday. My client was participating by Zoom. She lost her connectivity, and I was unable. We did proceed with the hearing over my objection, as I wanted it to be adjourned for my client to participate. She is requesting that we have the preliminary hearing today. She is waiving reading the entire petition as she's gone through that. And we are withdrawing our demand for jury trial, but we still do wish to have a bench trial in the event the court does determine there's enough to proceed.
Thank you. I'll look at that as I calendar our next events. Response, Ms. Thomas.
Thank you, Honor. I'm not sure legal name here, but the respondent mother was provided notice of the hearing last week. We all found, or the referee had found that to be appropriate, and we did continue with a preliminary hearing or removal hearing in which the referee was able to make the appropriate findings to move forward. I don't believe that a preliminary hearing is necessary today, but given that we were sort of expecting this, I do intend to take testimony from Ms. Trout to supplement the record. And other than that, I believe that we just need, we scheduled Dad's pre-trial today just to get some dates on our calendars.
Any comments, Mr. Brooks?
No.
Ms. Heiss?
No comments, thank you.
Very good. I appreciate the request. I will ask in your voir dire of your caseworker just to hit maybe your main points, and then of course we'll allow for cross-examination.
Thank you. Ms. Trout, please sworn in. Good morning, Ms. Trout. Just to refresh the record, can you please state how you are familiar with this matter?
I was the CPS investigator on the case.
Thank you. And as the investigator, are you the one who drafted the petition that's in front of the court today?
I did.
And in your opinion, do you believe that there remains a substantial risk of harm to the children's life, physical health, or mental well-being if they were to be in their mother's care and custody, or either respondent parent's care and custody?
I do.
And can you just briefly explain what that risk of harm would be?
Currently, in regards to respondent father, he is incarcerated and unable to take placement of the children. In regards to mother, there is concern of unstable housing. There has been allegations of substance use that has not been able to be confirmed or denied at this point. And then in regards to the dental neglect of Alice.
And just to refresh, there was some testimony, or there was significant testimony about the reasonable efforts that were put forth, and I argued they were active efforts put forth to prevent the removal. And one of the things referee noted was that active efforts would include something about, like, you know, in-home, getting mom to those services, especially because of poverty and lack of transportation. Can you just briefly highlight for the record whether those services were in fact in-home and provided to her directly, so she did not need to worry about transportation?
Yes, so we referred early on, and they would have been in the home due to not being able to make contact with mother. They did have to close their case. Safe care was referred. They are also in the home. There was multiple unannounced visits and scheduled visits made with safe care that were not successful until I believe it was the day before we filed the petition. They were finally able to make it in the home. And then we were in the works of referring families first, but due to lack of cooperation, that referral was not made, along with they would have been in the home as well.
So what are your options when a parent doesn't cooperate with services or with referrals?
Because this was a category 2, without cooperation, it is a petition.
Thank you. And there is some argument about, or indication that mother has reportedly stated Native American heritage. And you became aware of that information in September, I believe, is that correct?
Yes, I believe it was the end of September.
Okay, and then you sent to BIA the inquiry mid-November?
Yes, that's
Is that correct? Your Honor, may I approach the witness?
You may.
Ms. Chow, I'm handing you 3 pieces of paper. Can you please identify what those 3 pieces of paper are?
One of them is the certified mail receipt for the BIA dated 11/15. The second 2 is front and back of the green card that is filled out and dated November 24th.
Okay. And have you received any other correspondence from BIA?
Not that I have heard.
And then as it relates to placement, we already have an order removing the children. Were you able to locate the children after the hearing?
Not the day of, no.
And were you made aware of any messages from Ms. Underhill to other individuals about her intent as to whether she would comply with that order?
So the day of the hearing, I received a screenshot of text messages that were made. Respondent mother's boyfriend texted his aunt wanting a place to hide for a few days, saying they wanted to lay low and stay out of sight due to CPS trying to take the kids.
And in fact, you eventually CPS, or actually not even CPS, someone was able to locate the children?
Yes, the mother texted back and forth with the relative placement most of the day Saturday, and by Saturday afternoon, the placement was able to pick up the kids.
And you indicate that is a relative?
Yes.
Okay. And do you believe that the relative is provides an environment that is the least restrictive environment in placement for the children at this time?
Yes.
And are you continuing to ask the court to, are you asking the court to continue its authorization of the petition? Are you asking the court to continue its removal order?
Yes.
And I believe this was asked of you at the last hearing. As far as you're aware, what would be the recommendation for parenting time?
There's the standard DHS parenting time. I believe it is a few days a week, supervised for a couple hours at a time. But whatever works best with placement and that the court would like to order.
Thank you. Your Honor, I have no further questions of Ms. Trout.
Okay, Ms. Trout, was there did you supply a copy of the actual inquiry that was sent to the BIA to the referee by any chance?
I did not.
Okay. Would you be able to get a copy of that?
Yes, I can.
All right. Did you, Ms. Thomas, want to provide a copy of those documents for the file that you have? Or did you do that already?
Thank you, Your Honor. Actually, yes, I would like the court to accept the documents that Ms. Trout does have in hand. I know that we do need to supply the inquiry documents that were sent through, but I think it's necessary for our record, as we know, for ICWA purposes.
Are we talking the green card with the signature?
I believe so.
Fine,
Deputy, would
take
you
a quick
mind
look.
passing that over to Mr. McFarland and Mr. Brooks so they can have a look at that proposed exhibit?
Objection. Although I guess I would ask, because there is an original floating out there someplace, that we really probably should have that as the exhibit rather than a copy. That's the best evidence.
Your Honor, the court of appeals, I mean, from my understanding, even the court rule indicates that the copies are what's necessary, not the originals.
I can appreciate that, Mr. McFarland, but frankly, the copies are easier to put in the file. Their size.
Fine.
Did you have any objections to the admission of this exhibit?
I would ask the caseworker provide them electronically when convenient so that we can keep it with our electronic file as well, but I have no objections today to this.
Well, Your Honor, I do have an inquiry. Do we have the original that can be viewed? So we know that this copy is indeed what the original purports to be. I think we should at least have original presented to us so we know that this is indeed an exact copy of that.
Would you be able to get it available to Mr. McFarland?
I would have to find the original. I'm not the worker that works with all of our ICWA documents, so I would have to get with her and locate where the original is.
Mr. McFarland, I'm not telling you how to do your job, but I think a subpoena could be useful in this particular situation. Or if you need me to order that they produce the original for viewing, I could do that.
I would like just, in order, they can just actually send me a text, just a photo. That's perfectly fine by me.
Just a picture?
Just a picture,
Okay,
sure.
yeah, I can do that.
All right, I'm gonna receive this into evidence then, indicating that the request was sent, and we'll just look for the request itself, at our next juncture. All right, questions for this witness?
I do. At our last hearing, which my client didn't hear some of these questions, you indicated that you had a case service plan or safety plan, which my client was not following, correct?
I have no proof whether she was or wasn't following the safety plan.
Okay, so you're not alleging that she didn't follow a safety plan, correct?
Correct.
Okay. You also indicated today that you have no proof that she was abusing any type of controlled substances, correct?
Correct.
And I think last time you testified that she does have a constitutional right to request a subpoena for you to enter her house, correct?
I don't believe that was brought up at the last hearing.
Well, let me ask you today, you agree that she can deny you entrance to her house without a subpoena, correct?
Correct.
Okay. So it looks like the principal allegation here is that she was living in a tent in the backyard that had heat.
It had a heater that was connected and not, it would be considered a fire hazard, but correct, I guess.
Well, are you a fire marshal?
I'm not.
Did you have a fire marshal come out and tell you that it was a fire hazard?
I did not.
So you don't know that it's technically a fire hazard, do you?
Correct, I guess.
Okay. And my understanding is the homeowner said that the kids could live inside, and my client sent you photos of the kids sleeping inside on a couch, correct?
Correct.
So what else do you have against my client here of substance?
Lack of cooperation with a Category 2 investigation.
Well, what's the lack of cooperation?
So there were multiple services provided to help her assist with all of the allegations from during the investigation that she was not cooperating with. And it does have if there is an investigation and not communicating, not participating in services, and just not answering the door, does warrant a petition.
Right, but she has a right to remain silent, correct?
Your Honor, object to the line of questioning. Ms. Trout is not a law enforcement officer. She's not an attorney. This is beyond the scope of what her job is.
Well, let me rephrase, Your Honor. You have a handbook that you follow, correct?
Yes.
The handbook states that the client does not have to answer that they have a right to remain silent, correct?
Yes.
And you seem to be holding that against her, that she's exercising that right that's in your handbook, correct?
That is why we file a petition if it is necessary. True, they don't have to communicate with us, but if it comes to it, that's when we get court involvement, and that's why we're here today.
Okay. So, in the same way with your handbook, is that she doesn't have to let you inside, she has the right to refuse, correct?
Yes.
Okay. So, what services, other than not responding, not allowing you in, what services did she not complete?
There was the early on that she was not communicating with, and they closed their case early. Safe care, she did not communicate until the petition was brought to her attention, is when she did start communicating with them. And then there was just the ongoing worker in general.
In safe care, when did she start cooperating with that?
I believe it was the day before we filed.
Now, you are not the ongoing worker, correct?
Correct.
You have no firsthand information that she was not communicating with the firsthand worker or with the ongoing worker because you're not that worker, correct?
Other than what the ongoing worker has told me, I was not.
Well, did she give you documentation on this date, and this date?
Yes, she did.
So what dates are they?
I don't have them in front of me, but I believe they're in the petition.
Okay, so there's nothing outside of the petition is what you're saying.
We have our database that it's all documented through as well, and that's where I was getting the dates.
I'm saying there's no other dates other than what's in the petition, correct?
I would have to check, but I believe that's correct.
Matter of fact, my understanding is that it was the agency's position that you did not wish to proceed to court, but was on the advice of your attorney. Is that correct?
Yes.
Nothing further, Your Honor.
Mr. Brooks?
No questions.
Ms. Sykes?
Was Head Start offered to the family and refused to participate?
The oldest child was originally in the Head Start program. The day after I made contact with mom, she withdrew her from the program.
And dentist is a program that you requested her to seek out and she refused?
She did not refuse. She did make appointments, but did not take the children.
Okay, thank you, nothing further.
All right, I see in the petition that there were several prior complaints, but it's noted that only one was substantiated. Which one of the prior complaints were substantiated, if you know?
I don't know off the top of my head. I would have to look at her history. I'm sorry.
Okay. Is it true that she has another child who's in the guardianship that she doesn't have any contact with, if you know?
That is correct, and I believe that child has been adopted by her guardians.
And are you familiar with any of the reasons that that child ended up in a guardianship in the first place?
Originally, there was an investigation for her testing positive for substances. I didn't dig too much into it, but I believe that's what it was surrounding.
Well, I heard Ms. Thomas indicate that there was a potential drug issue in this case. I guess that's what I'll describe it as. Is that part of the reason that you're suspicious of this, or like what indicates to you that there may be drug use?
So there was that history along with I was made aware from other collateral contacts, and I received a set of allegations that she was using substances. The respondent father also made aware that he believes she's using substances along with other people that he has talked to, brought up the concerns to him.
If you know, did anyone from the department at the outset of the prior case, which resulted in the placement of the older child in a guardianship, offer any services, substance abuse analysis, assessment, or treatment for this parent in the past?
I don't know.
What are the specific allegations of drug use that cause you to be concerned that it's interfering with her ability to parent?
I believe there was, it was meth usage and that she was not supervising the kids. There were concerns that she has been locking herself in the room and the kids were kind of roaming around without supervision. Someone else also informed me that they witnessed the kids outside without supervision. Whether that's due to the substances or not, we don't know.
Do you know what condition the children were found in when they were turned over to the relative?
I do not. I do know a little bit. They did have a couple suitcases of clothes, but Rocky, or I apologize, the youngest child did not have any shoes. That's all I'm aware.
Do you know whether or not the father of the child attempted to make any arrangements to provide shelter, care, or support for his children after he was incarcerated, or before, for that matter?
We did talk about briefly how he wanted his mother to get guardianship of the children. But other than that, I do not know of anything else. Was
that explored?
Because she's in Ohio, it wasn't explored too deeply. Crossing state lines makes things complicated. And then the mother stopped contact with his side of the family.
Did you explore potential Native American heritage with any other relatives?
We didn't, or the father said no Native American heritage, but other than that, we did not.
What caused you to think that the children, one or more of the children would have needed early on analysis services or some of the other services that you asked her to participate in?
Due to the age, we usually refer to early on for category 2 just as a precaution. But with Alice's age, Head Start would be appropriate just due to her age. Other than that, Safe Care selected the children. That's not something we usually refer to. They have to select themselves, and I don't know their process of selecting the families.
What kind of services does Safe Care offer?
A lot of it is focusing on parenting. There's 4 separate sections of kind of what they focus on, and they work with a lot with the mother on different types of parenting skills. I don't remember any of the others. Usually that's an ongoing worker thing. Investigations don't touch with Safe Care much.
Okay. I saw in the petition that there was some concern with the children sleeping outside in a tent in late October. Is that right?
Correct.
It seems I would have a question as to whether or not this mother has employment or stable housing at this time. Did you inquire into any of that as part of your investigation?
She does not have employment. At the beginning of my investigation, she did have housing. And then at the end, she disappeared, and I didn't know that the housing was an issue until I found her in the tent. But she does not have stable housing.
Do we know why she doesn't have stable housing or employment?
I do not.
I have lots of questions, guys. Any or attorneys? Any questions based on my questions?
No, Your Honor.
Mr. McBride?
Getting back to active efforts and the question the judge asked you about you asking any other relatives. At our last hearing, I indicated that my client's father would be the individual who would know a particular tribe, perhaps, correct?
Yes, that's what you said.
Have you inquired of him as to any particular tribe?
I have not been able to make contact with him. The on-call worker over the weekend did. I'm not aware if she was able to talk to him or not.
What efforts did you use to get in contact with him?
During my investigation, I didn't have any efforts. Over the weekend, I was not working. So I didn't make any efforts.
Oh, you're
since
working
last
today,
week.
correct?
Correct.
Didn't try to call him 4 hours before, correct?
Correct. I have other investigations that I was working on.
Saying a 2-minute call would take excessive time on active efforts?
I don't think it does. I don't have his phone number currently. Whether the on-call worker got it over the weekend or not, I don't know.
Yeah, who's the on-call worker?
It was Jill Tipton.
Okay. Is she here to testify?
She's not.
Follow up with another of the judge's questions about drug usage. Was it you? Who was it who approached the door in which my client answered but wouldn't let the person in?
It was Jill Tipton.
Okay. There's no reports from Jill Tipton that she was in a state of distress such as drug overdose that she would have needed to call the police to file an active police report, correct?
Correct.
So you have no substantiated drug usage is what I'm hearing, correct?
I have nothing to prove one way or the other.
Well, yeah, you have a worker who viewed her and who didn't call the police regarding drug use, correct?
Correct.
So that is some evidence, right?
Sure.
Wait, did she view her or did she refuse to answer the door?
Brittany during that time did answer the door, but refused to allow her in the home or to drug screen.
Thank you.
So there's no reports that she had glazed eyes, speech was incoherent, or anything like that that you are aware of, correct?
Correct.
Now, this early on, just for the record, that is tell us for the record, what is early on?
Early on is a service offered to families, not always CPS involved. It could be just any family in the community through the tech center that work with younger children, make sure that they are caught up on any developmental, where they're supposed to be age-wise developmentally, and work with any services of catching up if they need it.
But you have no proof that these children are developmentally disabled, correct?
Correct.
So this is speculation that they were developmentally disabled, correct?
You don't have to be developmentally disabled to participate.
I understand, but my particular question to you is, you have no evidence to say that they that the kids are disabled in any way or behind in their development, correct?
Correct.
This is kind of preemptive in the event they are, correct?
Correct.
The kids don't have to go to school until first grade, is my understanding, correct?
I'm not aware of the age that they legally have to be.
The early on is pre-kindergarten, correct?
Yes.
Mayor, I'm going to object to this line of questioning. What is the relevance at this point? The whole point of the petition was the fact that there was no cooperation.
Oh.
The legislation is clear. So unless there's something outside of the legislation and the statute that you want to ask questions about, I'm failing to see the relevance at that point of question.
Well, it's a line of questioning that the court posed, and I wanted to follow through with part of the plan of what she was supposed to do, of what she's failed to do is not put the kids in early on. Is there even a reason for her to put the kids in early on to require this hearing? And that doesn't appear to be from the testimony I've heard.
I think you've established that at this point.
Yeah, that's all my questions that I had, so
Thank you.
I didn't have any further.
Any other questions, Mr. Brooks?
No.
Ms. Hines?
Just briefly, the father had a plan that his mother in Ohio might take guardianship while he's in jail, correct?
Yes.
And the mother didn't like that plan?
I'm not sure if it was brought up to her by the father.
So part of the department's goal is there's a temporary placement right now, but when ICPC can get the work done, the children might end up in placement in Ohio with this fella's mother, correct?
Yes.
Now, is she the same person that has that guardianship adoption with another child?
Not of the mother's other child. That grandma does have guardianship of one of the father's other children.
So it must be that these two children have a different father than the other child who's been adopted.
Yes.
Do those siblings know each other?
I do not believe that they have met the one that has the guardianship and possibly adopted out. They do know their other half siblings that are with another father as well.
Thank you, nothing further.
Thank you for your testimony. You may return to your seat. Any other witnesses?
No, Your Honor.
Mr. McFarland?
I'd like to see my client would like to testify today.
Okay.
Ms. Underhill, would you like to testify today?
Oops, sorry. I was gonna ask you to unmute and then you were too fast. I'll unmute again.
Yes, sir.
Ms. Underhill, would you like to testify today?
Yes, sir.
Ms. Underhill, I told the court you wish not to have this petition read. Is that accurate?
Yes.
I also told the court that you were withdrawing your request for a jury trial. Is that also accurate?
Yes, sir.
And I've gone over your rights with you last time when we were able to break out before the hearing. Is that correct?
Yes, sir.
Okay. And you indeed wish to proceed as we are today with this preliminary hearing. Is that also your desires?
Yes, sir.
Okay. Well, let's cover some of these major issues. They said that you didn't let them in, even though you have a right not to let them in. Is there a reason why you did not let them in?
It was just simply because I already was expecting them to be at my door, and I knew why they were at my door because of altercations that I was having with other people around me and wanting to cut them out of my life. They were toxic people that I didn't want around me, and they had expressed that they were going to do everything they could to make my life hell, pretty much. And so I didn't allow them in. I was upset about the situation and feeling the harassment, not so much from CPS at that point, but just from other people around, and just wanted left alone, wanted, just trying to have peace in life. And but there wasn't any particular reason other than just that I have the right to do that.
Can you elaborate who these other people are and what relationship they are to you?
There's several. There is Caitlin Sloan. She is a younger female who I had tried to help out and tried to be there for her. She doesn't have family around here, but there was a lot of drama with her and a lot of negative influences that she continued to be around.
Who else?
Jennifer Muniz, she is my uncle's ex-wife. She is also someone that I wasn't communicating with, and a lot about drama. They are all about drama. Misery loves company, and I just wasn't entertaining it. So they went about other ways, and they expressed to other people about the intentions that they had as well as myself.
They also expressed concern that you didn't answer questions that you didn't have a legal right to answer, but is there a reason why you didn't answer their questions?
I'm not sure what questions I did not answer.
Okay. Tell us about the tent.
Yeah, so the tent, I actually we stay with a family friend, who there's plenty of room for both the children and myself. We would be inside all throughout the day. I kept my things inside of the tent. There was a couple rooms that I was cleaning out to make room for my things, so our things were kept in the tent. And that was kind of like our space we would go to. We didn't have to stay in the tent. It was still warm outside when we were out in the tent. The day that they showed up was one of the first days that was the chillier in the morning. But again, we would be in and out as I was like our things were in the tent. So if I needed anything, we would go. That was like our own little space for the time being until we got the room cleaned up. But there was
Did
not
the kids
ever.
then indeed move inside the house after that visit?
Absolutely. We were already in the process of moving inside the house for the further going because it was getting colder. We had only been outside by choice because it was warm outside.
They also indicate that you didn't take drug tests, even though you have a right not to take them. Is there a reason why you didn't want to take a drug test or refused?
Yeah, because I had consulted a lawyer. Just got to consult just to see how to go about the situation. And they went over everything. And one of the things was if they had like what the allegations were, and there was never, even up until I had read the petition, nothing has been brought up about any drug allegations whatsoever. So I was advised to refuse it, which is what I did. And there's only been one time that I was asked to take a drug test, and that was with Jill.
Okay. Now, apparently this worker doesn't know about the earlier guardianship. Did that guardianship have to do with anything with you abusing controlled substances?
Absolutely not. And I've not ever had a positive drug test whatsoever. And Mila, my kids do know who she is. And even Alice has met her sister a couple times. That's a very toxic situation with the father. And there's a lot to that on why they have guardianship, or I guess they have adopted her.
Do you think people are falsely reporting that you're abusing controlled substances?
Absolutely.
What would be the motivation for them to do that?
Anything that they can to cause any kind of havoc in my life. I was starting to do pretty good. Being that me and the kids were really happy and not letting people just stay over. It was my aunt and uncle's apartment that originally they were evicted, and the landlord had allowed me and the two children to stay and take over payments for rent. And they constantly had a lot of people there. So people that were used to coming and going and were no longer allowed to be there, and they kind of were upset about that.
Let me touch on a couple other areas. They had a concern that you don't have a place for the kids. Do you have a place for the kids before they were removed during the weekend?
Yes,
A suitable place?
absolutely.
Okay. I'm not asking if you have employment right now, but do you have sufficient income to support your children?
I do.
And what is that support? What is that means of support that you have to raise them?
Right now I'm cleaning houses that are being worked on by the landlord here. I'm being like subcontracted by the fellow that I stay with. He is the main worker that does all the work on all the houses for the landlord. And he has hired me to come in and do the cleanups on it and little odds and ends like painting the trims if painting needs done and whatnots.
Do you think we've covered the highlights? We still have the right to trial, but do you think we've covered the highlights as to why the children shouldn't be removed today?
Yeah, that's quite a bit. And I know that as far as I would like to say communicating, I did express to the caseworkers when they had come to see me the day before the court hearing originally. I already battled depression pretty good, and I've been my world's been shook upside down, and I'm not used to not being independent, so this is really hard for me. But I told them that communication has been hard, and it's not just been with them, it's been with my other children, with other family. I'm constantly busy. I don't have my phone in my hand. I'm running around after kids and doing other things that I just don't seem to have. And I've told them that we make appointments just to show up. They don't have to call to show up, just to show up. And they were actually in the house. Two of them were in the house when the parent teacher or the parenting class lady showed up to the front door knocking. We could not hear her. We could not hear her at all. So
how do you know that she was there?
And we only knew that she was here because she had contacted the two CPS ladies and told them that she was here and that she was knocking on the door. And they had even made the remark like, man, you really can't hear. I said, no, you really can't hear the front door. That's why we use the back door.
Okay. If this court does uphold the removal of your children, are you okay with the placement with your brother?
Yes.
Okay. Next, would you like as much visitation as possible? The standard is typically 3 times a week at 2 hours a visit. Is that something that you would be able to keep?
I would be able to keep that, but I would, if possible, ask for more. I mean, me and my children have not been apart from each other. Like, I have been there since day one for my 2 children, and this has been very traumatizing. And
let me ask you, would your brother allow you to live with him, with the children, with him being a supervisor?
yes, he would. And
are you asking the court, number one, to consider that?
Yes, actually, that is something that I was wanting to ask if that is possible.
And if not, what's the if not?
If not, then I was going to make other arrangements to be able to be in Adrian, and that way I could be there throughout the day or be there as much as possible that I'm allowed to be there. And then I could go and sleep somewhere else until I get our housing, because I've been working on housing.
Lastly, you need transportation. You have transportation issues, correct?
Yes. And
you have somebody that can give you. Do you have somebody that can give you rides that you could? That gas cards would help, or do you physically need to have dial a ride call Lenawee Transportation, I should say, and take Lenawee Transportation into visits? Can you tell us?
It's the actual transportation part that has been, it's not been the gas money part, but I am going to and willing to place myself in Adrian so that way I'm there and there will be no need for transportation. That way transportation won't be an issue.
Okay. I'll see if other attorneys have questions for you, okay?
Okay.
Thank you.
Ms. Underhill, isn't it a fact that your child was in Head Start last year?
Yes.
Is it a fact that they brought concerns to you about her oral hygiene?
Your Honor, how is this? I'm asking the relevance. If the objection was made by the attorney for the agency, my relevancy with this line of questioning.
Read the petition. Didn't?
Okay, so this time, hang on. the objection is overruled. It is directly in relation to the allegations in the petition. So for those reasons, it's okay.
I actually had brought those concerns to the Head Start teachers myself because it's something that I knew that needed to be taken care of. And I had expressed many times to people around, transportation was an issue. And the dentist here in Hudson, I couldn't get her into them. They weren't taking new patients or her Medicaid, which was an issue, which had been an issue.
For 11 months?
Yes. I have not been on Hudson, but 2-3 times.
You answered my question, thank you. And isn't it a fact that CPS, you have heard, in fact, CPS knocking at your door, or you have had appointments for CPS to come and visit, whether it was in your own apartment or at your current location?
That I have had appointments for them to come and visit, they have come and visit. Like when they
open the door every time.
I'm sorry, what's that?
You have opened the door every time.
I can't say that I've opened the door every time. If I've heard them, if I have heard them, then yes.
You said you wanted peace and to be left alone, and that all these allegations are false. So why not prove them false? Why not cooperate?
Yep, I'm able to prove them. I'm able to prove them false. I've been gathering my proof for that.
Okay, so you'll come in town and take a drug screen if the court orders it today?
Absolutely.
Okay,
and I'm open to random drug screens as well.
And just like you presented CPS with your children after the court ordered it?
That I presented my children. I gave when I contacted my brother.
No, can I have
I told
clarification? And the reason is my client was lost communication during our hearing, so she wouldn't have heard the order. So I'm
Mr. McFarland, you're welcome to argue. Do you have an objection?
I do. She's misconstruing to the court what happened at our hearing. My client was not present when there was an order to turn over the children, as we had lost contact with her.
You're allowed to cross-examine. I don't think that officially qualifies as an objection under the court rules.
Okay.
Go ahead.
The Senate representation is a question to your
When my brother contacted me and told me that he was supposed to take over them, we made arrangements for him to come and pick them up.
And your boyfriend did not send a message to anyone stating that you guys needed a place to hide for a couple of days?
I was unaware of anything of the sort. I can't speak on his behalf. I don't know why he would do such thing.
Okay. And you stated that your older daughter, she was not born as a drug-exposed infant?
Which one? My older daughter. I have 2 older daughters.
That was put in the guardianship?
To THC, yes. Before it was legalized, I had used marijuana to help control my nausea. After she came home, I passed every drug test.
And thank you. And then you mentioned that your mental health is so severe that you don't talk to anyone or see your other children. No,
please don't twist my words. I do see I see my other children often. And they can vouch for that. Their father can vouch for that. What I say is I battle with depression, and I get to where my phone is the last of my worries. I'm not keeping track of my phone. I have 2 younger children to run around after, and anybody that's been around them knows you have to be on top of them. They're very, very active children.
So, and why did you pull your daughter with A, first name, out of Head Start?
Because we were moving out of my apartment, and I actually was hoping and planned on moving out of Hudson, and that's why I had pulled her.
Okay. And it's your testimony today that you don't use any substances?
Absolutely.
Okay. Thank you. I have no further questions.
Ms. Heiss?
No questions, thank you.
Any redirect?
No.
I do have a question. Ma'am, are you legally married to Zane Ridenour?
Yes, sir. I have put in I have started divorce, but it's not been finalized yet.
Has it been filed?
No, that's something that I just have done.
What is your legal last name?
Underhill.
Not Ridenour.
No, I did not get a chance to go and get my last name changed before we decided divorce was going to be something that we both agreed to.
So your legal last name is Ridenour, or
No.
excuse me, Underhill.
Yes, sir.
Thank you, that's all.
You're welcome.
I have a follow-up to that. Ms. Underhill, was either of your children born during the time that you were married or have been married to Mr. Ridenour?
Actually, either one of them. We were not married when they were both born before we got married.
Thank you.
I did do a DNA test for Zane, and I do have the results for that, and they are both boys.
That gives me another question.
Me too. I know what you're gonna ask.
I noticed we have what's called an affidavit of parentage for your son. For your daughter, is there anything indicating that Mr. Ridenour is the legal father, biological father?
That I do, like I said, I did have a DNA test done, and I do have the results for those, both paper copy and electronic copy I have. The only reason why that did not get filed correctly was because we were in Ann Arbor, and there was quite a few steps that needed to be taken before he had left, and so that's all that's the only reason for that.
Are you willing to sign an affidavit of parentage saying that Zane Ridenour is your daughter's biological father?
Oh, absolutely. You can't deny that, not even if I wanted to.
Thank you.
Yes, sir.
Anyone else have questions?
No,
One follow-up. Was that DNA test done through a court proceeding, like for child support or anything like that, or just privately on your own?
Nope, I went about it myself, and I
Okay.
paid for it.
That's what I wondered. And there's absolutely no possibility any other man could be the father. Is that what we're hearing?
Correct.
Okay, nothing further.
Okay, anyone else you'd like us to hear from, Mr. McFarland?
No, thank you.
Mr. Brooks?
No, Your Honor.
Ms. Heiss?
no witnesses today, thank you.
All right, very well. I would like to offer to you January 3rd for purposes of an adjudication trial for both parents. That's at 9:30.
That's fine.
Your Honor, would I have permission to Zoom for that adjudication trial that time?
Any objections?
Visiting in Grand Rapids for children is what I was hoping to do that day.
No objection.
No, I have no objection.
Thank you.
I can also give you a backup in the morning. We can use January 16th, a Tuesday, as a backup to another trial that I have set for that morning.
Your Honor, I would request more time, just given the holidays schedule with the workers being unavailable, as well as myself, for the 16th.
All right,
No.
yeah, if I give you this, it's either the 16th or then you're out to Friday, the afternoon of February 2nd, so.
Your Honor, my client would rather not. In the event that the court does not find this jurisdiction, then my client has been without her children unnecessarily. So we want the earliest date possible.
All right, is everyone available the morning of January 16th, commencing at 9?
Yes,
Yes.
Very good. Okay, so let's set that for our adjudication date then. Do you need can we just use that as our next date, or do the parties?
Again, it's at 9:30,
9 o'clock,
9 o'clock.
January 16th, commencing at 9. I was gonna ask if you needed a pre-trial, but.
I don't see so.
I don't think that's necessary.
All right, so let's do that. Any comments in closing?
Your Honor, on Friday, I made a substantial closing argument, and I guess I'll just highlight the salient points. When this petition was brought to me, they were asking for in-home jurisdiction. And after reading it and conferring with the department, the in-home component was wholly concerning because none of the individuals inside the home are appropriate to be alone with the children. If mother works, I'm curious who's providing childcare because they're not in educational programs. And the whole point of the legislation that is enacted by people who have decided that this is what we have to do, we are following the law and we are trying to do our job. And it's insulting when workers are continuously questioned about the efforts that they're putting forth. We are limited to the reasonable efforts and services that our community has available to them. In each case, we are trying, and the department is trying diligently to ensure that families have the resources necessary in order for their children to be safe. And when there's a parent who refuses to communicate, we had testimony on Friday that we did not, I guess, elicit today about all of the efforts that were made to communicate with Ms. Underhill, the times that she admitted that she heard them at her door and didn't answer it, the times that they did have scheduled appointments and she just didn't answer the door. All of those things, in addition to just, if you don't do drugs and you want to keep people out of your life, why not take that drug screen? Mr. McFarland has made the point that she doesn't have to, it's not her right. That's absolutely true. But it is then now our responsibility by statute to file this petition. And that's exactly what we did. So for those reasons, we believe that because none of the concerns from the complaints could be confirmed or denied one way or another, we take the complaint at face value, and the custody of the children with the parents because of incarceration or lack of care have and do present a substantial risk of harm to the children's life, physical health, and mental well-being. The services, there were active efforts put into place, and those did not amount to anything to alleviate those concerns. And so we are asking the court to continue that removal, as it is the only reasonably available resource to adequately safeguard the children. And we believe that placement with the maternal uncle at this time is appropriate and allows for the children to be in the most home-like setting and is the least restrictive environment for them. And for those reasons, we just ask the court to continue authorizing the petition and continue that removal order. Thank you.
Mr. McFarland.
Just because a person exercises their constitutional rights does not mean they're guilty of anything. I realize this is not a criminal setting, but she has the ability to say that. Of course, the agency has the ability to go ahead and file the petition. But we've heard today, there is no direct evidence that she's using any type of controlled substances. On the contrary, we have an ongoing worker who was there, viewed her, did not call the police, did not observe that she was using drugs or anything of that nature. We have a whole lot of hearsay that she may be using it, nothing to substantiate that. We have children who legally do not have to be in school. They're saying that this is maybe a preventative measure, but nothing that would say that there are any problems that they need to address by going to this pre-required school or training, Your Honor. The issue with housing occurred in October. Here we are, December, almost January, and there's no testimony that she doesn't have housing for the children right now. There's no testimony that she doesn't have income. Matter of fact, the testimony we heard from my client is she has housing, that she does have income to support these kids. At this point, I don't think there's enough for a preliminary examination. I know the court's scheduling adjudication trial on this, but we are asking, there's also another alternative. If the court does determine that there is enough for the removal of the children, and that would be the ability of my client to live with a relative and continue a relationship. My understanding from the testimony is this brother is living with the minor children here in Adrian. I haven't heard any testimony where there would be any type of risk of harm to the minor children if they were to live with mother and brother. I haven't heard any testimony that there's not enough room or that he's not willing. Testimony is that he would be willing to do that. So that's what we're asking. And the alternative, that my client have at least 3 hours or 3 visits, 2 hours per week, and she'll be moving to Adrian. And until she does so, that I guess she may need some help with transportation from Hudson, but sounds as though she'd be moving to Adrian pretty soon. Thank you.
Mr. Brooks?
This is not my client's hearing, and I have no argument to present.
Ms. Heist?
Your Honor, although the mother has a right to not answer the door, the child has a right to safety and to live in an environment where the risk of harm is acceptable to community standards, to a reasonable person. With her exercising her right to not answer the door, I ask you to exercise your authority to allow us to assess these children, evaluate the children. The couple of times Protective Service and law enforcement were able to view the children, they were in deplorable conditions. I would ask you to consider that mother had at her fingertips the ability to show us that she's not using drugs and didn't take us up on that ability. I mean the agency, up on the offer to do a screen and to show us that that isn't a barrier to her reducing the risk to the children. I would ask you to consider continuing the placement order and continuing us for adjudication trial. Thank you.
Thank you. Well, the court finds all interested parties are given notice for purposes of today's preliminary hearing. The pretrial that was indicated by the referee last week was conducted in addressed, I think, as a part and parcel of today's preliminary hearing, and my order will reflect that. Both parents will be set for adjudication trial on January 16th, 2024, commencing at 9 a.m. So we will make sure that Mr. Ridenour is available to us if we can through the jail. And Ms. Underhill, you're welcome to join us in person or again by Zoom if you have a good connection. It is your responsibility to make sure that you have that good connection or to make arrangements to be here. I do understand also that we have a caseworker here and that many times the caseworkers are able to arrange transportation. So on the 16th, if you are not able to join us, I will assume it is because you were not in communication with the caseworker to make those arrangements or not able to find a signal. And we will proceed without you unless there is some kind of documented emergency, frankly. The findings made by the referee supplement the court's findings today that there continues to be evidence in this case at a level of probable cause that the intervention of the Child Protection Services and the court is necessary. We do have indications that there was at least one older child born positive for drug use from what Ms. Underhill indicates is THC, and we have some other indications in the petition that indicate that there may be drug use resulting in neglect, and that would be reflective of some of the allegations where people have found the children in deplorable condition, as Ms. Heist described it. There were indications that the mother was locking herself in her room and was not taking care of the children. We also know from testimony that at least one of the children had dental concerns that needed to be addressed. Very young children, cavities can cause loss of teeth for a significant number of years at their age. She knew that that was something that needed to be attended to and had not attended to that from one school year to the next. So that had been a red flag. We also don't have evidence of any kind of employment or housing that would allow her to support the children as she needs to in order to provide for things like diapers and shoes, for example, and education and healthcare. So these children are at substantial risk of harm if left in the care of Ms. Underhill. Mr. Ridenour is not available to take them. He's incarcerated at the moment. There are some other issues, I think, also that he would have as challenges in the event that he were released. I'm not seeing much here that shows me that he has much of a relationship with the children and some indications of criminal and Child Protective Services history that would cause the court to ask CPS to certainly look at those to make sure that the children will be safe in his care as well. So for all those reasons, as well as the reasons already articulated by the referee, the children will remain in the care and custody of the Department of Health and Human Services. I want to say I appreciate the department making sure that we have found a relative that's willing to hold on to the kids for a while in case that needs to happen. One of my concerns in looking at the paternal grandmother, for example, was that that might have required two different placements. In order to really explore that, I asked the department to do that. They did that. They articulated the findings of those questions to the referee, who did make that determination that removal was also appropriate for the reasons that she placed on the record. And I think that this is the safest and least restrictive under the circumstances. I will not authorize the mother to move in with the relative caregiver at this time. I think that she needs to cooperate with the department with the investigation and moving forward. She certainly has the right to do that, or the right to continue to deny allegations and proceed to adjudication trial, which has been set for January 16th, 2024, commencing at 9 a.m. In the meantime, I will ask the department to implement supervised visitation for mom and to produce a recommendation for any contact between the children and their father. Professional recommendation, as well as, again, that inquiry sent to the Bureau of Indian Affairs to complete the investigation that way. As it relates to information that may be held by another relative, I'll just ask you for your best efforts. Obviously, the parents should be willing and able to supply any contact information that you need. And if they're not able to do that, I don't expect you to put on your private investigator hat and track them down individually, but just to do give us your best efforts in making sure that that's been covered. Are there any other questions pending adjudication trials?
Yes, there are. It seems as though we have one child with not an affidavit of paternity who was born outside the marriage. So how are we going to address that?
Thank you. I do have that actually addressed in the order, and I will read that onto the record as well. What I'd like, Ms. Stroud, is for you to look at the AOP from a state level to see if that's been filed, and if not, then to offer DNA testing for Mr. Ridnour if he would like to, in order to determine whether or not he is the legal as well as biological father of the child. I know we have some indications from the mother today that he is the legal father, and we'll continue to look at that at the next juncture as well. But in the meantime, if you can find anything to substantiate that, I do appreciate it. Any others?
Your Honor, I do have a copy of the AOP for the younger child. So I know that those AOP searches were done. We can work on even perhaps trying to coordinate an AOP signing for the older one. And then as relates to the ICPC request, I guess just clarification as to whether you are asking for that to be completed. I know that the department still would like that to be completed, and I think for the expedited process, there has to be the language in the order.
It's very specific what needs to be written in the order if we do an expedited ICPC.
But I fully recognize that we did not take testimony on some of those points, such as the substantial relationship, other than the fact that it's a grandmother.
I did see that that was addressed at the prelim. And that there was an indication that the grandmother in Ohio was identified, but that she believed that Adrian was a better option for the children. Is she still seeking to be evaluated for placement?
She still does want to be considered.
Okay. My order will certainly contain the language that all other prior orders not in conflict remain in full force and effect. Do you need me to absolutely reiterate this language, or can you?
No, Your Honor. No, that's sufficient. Thank you.
Any other questions?
No, thank you.